Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D Lerner. Today, we're talking about 245I and all of the ramifications. Now, when you go to an attorney's office in order to find out what you might qualify for, um, if they know what they're doing, they'll always ask you, was there any petition filed on your behalf? And if so, who filed it and when? Was there an employment petition? Was there a family-based petition? That's all to determine if you're under 245I. So if you did have something filed in the past and the attorney doesn't ask you these questions and says, well, you need to leave the country and possibly have a bar of 10 years, you either want to question that attorney or go to someone else who specializes in immigration law to determine whether you're under 245I. Now, another question that needs to always be asked is, okay, well, if you didn't file such petitions, do you have anyone else in your family who filed petitions, such as parents or siblings? Do you have a prior spouse or an ex-employer in order to determine if there's any basis whatsoever to get you under 245I? And even if the relationship is a bit tenuous, and even if you're clearly not under 245I, but there's a gray line which you might be, it would be worth fighting for it in the adjustment to avoid having to leave and be subject to the 10-year bar. So even though 245I has been around for a lot of years, over a decade, you'll want to uh, see if there's any possibility at all that you might get under it, and if so, be sure to fight it to try to adjust. Okay, more on the coming videos.